either are or were in a relationship,
We dated. We don't live together. Never have lived together.
but you dated.
A little bit. Yes, Your Honor.
And both she and Ms. Gogan work at DSHS.
Correct, Your Honor.
Okay,
There's
as do you.
yes, 30 years.
Okay. And
So
are you in their supervisory chain of command?
can I explain that to you, Your Honor? So I work for the Office of the Secretary. Mrs. Gogan, her she's administrative assistant for our boss, who is the second in command of the whole department. Lisa Yanagita is the chief of staff. Okay. So that's where part of and where the problem lies is that per our administrative policy that I think I attached there for you to look at, she's violated that. And as I move forward and present a lawsuit and everything else, because in this, in some of the photos I sent you, um, she sent these memes and information around to the office. And if you see the one that I sent you, she where it says in there, do you see who's on there? And I'm a coworker. Where she says, dude, I would normally message a coworker, but I can't stop laughing. So here it is in this office where you're the admin assistant to the second highest person in our administration. And now, how am I supposed to work with you every day and trust when you're discriminating and um, doing all these acts of inappropriate behavior in the workplace? And so, part of my action is I'm probably going to file a lawsuit against her. And so, I need that protection for me because, per our policy, this administrative policy, she's probably going to lose her job because of that. Um, she even the words that she uses where she knows what she's doing is right. I wouldn't normally message a coworker, but I can't stop laughing. um I'm and then even looking at this, she talks about how she's in this picture with her boyfriend, but she's on this single dating site just for kicks. And then the meme that she puts in there, where and she makes a comment, and she's like, all these things that she's doing uh, affect me greatly, and it's an issue and it's a concern. And once that lawsuit drops, it's going to be a problem. So that's the Gogan thing. And then if you look at the administrative policy on number three, actions that violate this policy aren't limited. Um, Violations via phone, email, text, social media, electronic communication. Um, Such behavior can also be outside of work. Um, it specifically speaks to this in our administrative policy.
So as to Ms. Gogan, your concern is about her posting something online.
Well, in the workplace. So,
Okay, and what about Ms.
so let me finish this, please. Let me finish this.
Well,
So, I also have currently the Washington State Attorney General's office. I have a motion in with them because these folks are up. There are putting photos online without the permission of um,
who's doing it?
um, Are We Dating Him Too? It's a site that's it's a group that's embedded into Facebook. And currently, I have a with this attorney generals to take that website down because they are putting males photos up without their permission, and there are women who are on there that are anonymous, so you don't know who it is. It could be any bandwagon person like Miss Gogan, who's in a dating relationship, who jumps on there for giggles and can post anything she wants. There's not It's libel and it's slanderous. And here I work with this person, and you're going onto a website like that where um,
The case you're about to witness isn't a high profile criminal trial or a life changing civil lawsuit. Instead, it begins with something surprisingly common in today's digital world: workplace drama spilling onto social media. One employee believes online jokes, memes, and public criticism have crossed the line into harassment, while the court must determine whether hurt feelings are enough to justify legal protection. As the hearing unfolds, the judge is forced to separate emotional frustration from actual legal standards. Throughout this case, you'll see a fascinating clash between personal reputation, workplace conflict, and constitutional free speech rights. The biggest question isn't whether the comments were kind, they clearly weren't. The real question is whether being mocked online is something the courts can legally stop. Stay until the end, because the judge's explanation becomes a lesson that many people using social media.
In your position, this is, you don't like it, and things should happen at work because she's violating work policy and so on and so forth.
So what if something happens,
So-
Your Honor?
Well, we can't do something proactively here. We can only do something if it meets the statutory requirements. So if she gets fired because you complain about her, whatever she posts about you, and she gets fired because she's violating the DSHS policy, which sounds like that potentially could happen. Then if she starts calling you and threatening you, then we can give you a protection order. But right now, you're just saying she's going online and telling the world that you are whatever she is, she's laughing at you or whatever she's doing. And the same for Ms. Krusich. Is that, I don't know
Yeah,
if I'm
that's
pronouncing
correct. Yeah. that's
Yeah.
correct.
And same for Ms. Krusich. They have the ability to do and say that. I can't tell them to stop. DSHS can. They can say you're violating our agency policy,
Mhm.
and for doing so, here's the sanction, whether it's whatever it is, firing or loss of pay, or give up your computer or whatever.
Right.
They can deal with that. I can't. This is not the appropriate procedure. You can file civil lawsuits
Oh,
against
yeah.
them for the
Yeah,
damage
That's coming. Yeah.
that's you feel
Yeah.
has been caused to you, and your harm of your reputation and those things. Those are actionable potentially with a lawsuit,
Mhm.
but this process isn't meant to address that. So you're not going to get any, what we would call a remedy
Oh,
out of this. I can't give you anything that will address it. So, so I'm just going to enter denial orders on these and not send them for a hearing. For that reason, I'm not, and I want to be clear, I'm not saying that what you're having to deal with is too small for this or anything. It's just, this is not the appropriate process for that.
oh, that's fair. For me, it's about exhausting all my means.
Yeah.
So
No, I
it's
understand.
not an end all for me. It's just another bullet in the process for me.
I get it. Certainly be frustrating to have a situation like that.
No, the frustrating part is that there are other males that I know that are black males that are like me that have been dealing with this on these websites, and that's I'm not sure. I think there's a point in there where Washington State is a two-party consent state. I just haven't dug it deep enough, but I believe I've seen that in there.
The judge immediately starts gathering the basic facts instead of jumping into accusations. Before any legal decision can be made, the court must understand the relationship between the people involved, whether they work together, and whether there's any history that could legally justify a protection order. These opening questions may seem routine, but they often determine the entire
custody or pretrial because he wasn't able to get to Panama City.
Okay. Come on up, Mr. Williams. Okay.
Judge, he had been offered a pretrial intervention. We had supplied that to him, and I'm not sure what his intentions are. All right.
You understand a pretrial intervention is an agreement you have with the state that's basically supervised by the probation and parole, and then the case is dismissed if you successfully complete that term. Pretrial intervention is a program that's offered by the state, and it's supervised by the Florida Department of Corrections. It's like probation, but it's not probation. It's an agreement that if you successfully complete the pretrial intervention, the state drops the charges against you.
I spoke with my public defender and he gave me the terms and the things that I have to do, and I didn't agree with him.
Okay,
And I don't understand.
sir.
I don't understand. So like the charges would be dropped.
The petitioner spends much of his time describing workplace policies, internal complaints, and possible employment consequences. While those issues may matter to his employer, the court is focused on something much narrower. A protection order isn't designed to resolve office disputes or punish unprofessional behavior. It exists to prevent unlawful harassment, threats, or violence. That distinction becomes increasingly.
We had several phone conferences that were scheduled.
Yeah, we missed a lot due to the time difference.
Sir?
I said, but we missed a lot due to the time difference.
He was on Eastern time and he would call an hour late.
I mean, a pretrial intervention is about as good as it gets. If you can take it or not take it, are we ready to set it for trial?
Yes, sir.
I don't want to do trial.
Well, then Mr. Meredith has done exactly what he's supposed to do for you. He's got the very best deal worked out for you. If you abide by the terms and conditions of the pretrial intervention, the state will dismiss the charges.
So the charges are brought upon me are by the state.
Well, who do you think brought them?
I thought I had a party.
Huh?
I thought it was an injured party.
The injured party, aren't they dope cases?
What is the jurisdiction of it? Is it criminal or
I
civil?
don't think you're near as smart as you think you are.
I'm just asking questions.
Yeah, you're not. Your possession of a controlled substance, giving false name, causing adverse effect. I guess there could be a victim on that. And resisting officer without violence. So, I don't know anything about the case, but it looks like you might have got a false, gave somebody else's name.
You just told me that the state was the.
The state's the only person who can charge you. Nobody else can charge you. It's the state. The victims can't charge you. They're just the alleged victims. They can't charge you. They can't do anything except make a complaint. But you've got offered a pretrial intervention. If you do the pretrial intervention, the state will drop the charges against you. If you don't meet the pretrial intervention, you come back to court and you start your defense again.
I don't wish to argue the facts.
Let's set it for trial.
Yes, sir.
Let's set it for May 5th at 8. Let's set it for June. What was that June date? June 2nd at 8:30. And it will be May 23rd. Yes, sir. At 1:30 for trial management. Okay. And if you change your mind and want to enter the pretrial intervention.
At this point, the case shifts from workplace conflict to online speech. Many people assume that if comments are embarrassing, offensive, or damaging to their reputation, a judge can simply order them to stop. But the legal system draws a very careful line between speech that is offensive and speech that is actually unlawful. That's exactly the issue the court is about to examine.
Attorney Richard Bruson, and my bond number is 35222, and I am the attorney for the plaintiff.
All right, and it appears to me that there is a motion to set aside the default judgment that was entered in this matter. That motion was filed on January the 29th. All right, and do I have Jennifer Moore on the Zoom?
Yes, good morning, Your Honor.
All right, thank you, Ms. Moore, and good morning to you, ma'am. All right, and it appears that the plaintiff is moving. That's right there. Yeah, well, no, I see the plaintiff's answer to the defendant's motion to set aside the default judgment. Now, tell me why you believe that the default judgment should be set aside in this matter.
Well, to start off, I did call LVMV funding when I checked my credit score, and that's how they were able to reach out to me. They were sending information to a different address, and according to Site 15 USCA 1692-, I asked for a debt validation. I asked for the payment of history. I asked for a signature of contract with me and the creditor. I also asked for if there was any insurance claim filed, as well as the title of chain. of this contract. And I didn't receive any answer. Next thing I know, my mom was dealing with pancreatic cancer. I'm an essential worker. I have 2 disabled kids. So when they were sending out these motions and so on, I was unable to receive them because I wasn't getting any mail and so on. So, and I reached out to the creditor and they said that they gave my account to Midland. I have since resolved the issue with Midland and it is paid. I then reached out to LV. They failed to give me all my information document needed. And now we're here.
The petitioner now lists his military service, education, professional achievements, and leadership positions. While these accomplishments may help explain why he feels his reputation is important, courts generally decide cases based on evidence and legal standards, not personal resumes. The question remains whether the conduct itself satisfies the legal requirements for judicial intervention.
I'm looking through my file right now, including electronic notes. I am all the way up to October of 2024. And of course, the register of action notes that judgment entered in this matter on June 12th of 2024, based on personal service of the summons and complaint. As I continue at the moment to keep scrolling down, I see that the first time defendant called my office, according to my staff, is December 5 of 2024. December 5 of 2024. And then, again, under 1692 of the act that she's citing, validation of debt notices go out within the first 30 days of the initial demand. Defendant was way beyond that period. Judgment was already taken against her. And so the case continued. I can see that she filed an objection to the wage garnishment in this matter back in December of 24. And then the matter was argued on January 8th, Judge, on your record. She told you at that time, to my appearance attorney, that according to her argument, that, quote, the matter that's before Your Honor was with Midland funding, which she paid. You indicated that she was attempting to attack the underlying judgment. The balance was given to defendant at that time of January 9th. So basically, as we've gone on now, Judge, by virtue of garnishment, there's about $89 I see statutorily owed on this case. I was frankly prepared to file a satisfaction of judgment. Oh, I see also, to perfect the record, that January 23rd,
I can't hear.
this case was argued. I'm not done, madam. The case was continued to present. And so here we are now with good.
Mr. Rosen, I'm stopping you because your device was breaking up. And that's what the defendant was saying, is that she's not able to hear you. I was going real smooth there until about that last minute, and something went miserably bad. And so you're going in and out. You indicated the last thing that was clearly heard was that you prepare to offer a satisfaction of judgment. You said only about $89 or so was all.
Exactly. Yeah, that's right.
After that, we weren't able to hear you very clearly.
Okay, so Judge, there's less than $100 owed now, which was addressed back on the previous hearing in January. Just a second, I was there. You adjourned the hearing to the present date. Yes, January 24th, we were last on your record. Now the judgment is pretty well paid, and I am prepared at the moment, well, I'm prepared now to file a satisfaction of judgment because it's all paid. I have no idea what the defendant is otherwise arguing about, but on that I rest.
Well, for the rest of your honor.
Excuse me. Let me ask you, Mr. Rosen, obviously, there's some.
The discussion moves toward anonymous Facebook groups and online dating pages. The dispute becomes even more complicated. Anonymous internet communities often create frustration because identifying the original poster can be difficult. However, Frustration alone doesn't automatically transform online criticism into a matter for a protection order. The judge must determine whether any actual legal boundaries